Monday, August 17th, 2026, brings a robust haul of 43 federal appellate decisions across multiple circuits. The day's cases feature 14 rulings from the Ninth Circuit, 9 from the 11th Circuit, 6 from the 8th Circuit, and 5 from the 10th Circuit. Topics range widely, including 7 sentencing guidelines cases, 5 civil rights matters, 3 firearms disputes, 3 immigration issues, and 2 civil rights employment cases. Dispositions show 35 affirmances, 3 reversals, 2 denials, 2 dismissals, and 1 reversed and remanded ruling. Notable movement includes the 11th Circuit reversing a summary judgment in a civil rights case involving Section 1983 claims against a county clerk. Another 11th Circuit decision reversed and remanded an ERISA dispute regarding fund comparators. The 8th Circuit reversed a denial of summary judgment granting qualified immunity to a nurse in a Section 1983 action. In the Ninth Circuit, the panel reversed class certification in a consumer protection case involving egg labeling standards. These rulings reflect significant legal developments in civil rights, employment law, and administrative review across the nation's federal appellate courts. Visit doitforthecaselaw.com for the full audio podcast and complete written coverage.
Let's turn to James covering criminal justice.
Thanks, David. 20 cases arrived from across the federal circuits today. The disposition roll-up shows 19 affirmances and 1 dismissal. Leading with the high-stakes matters, the Ninth Circuit issued a significant order disqualifying Sigil Chattah from supervising prosecutions in the District of Nevada. In multiple decisions, including United States v. Salazar del Real and United States v. Jackson, the court held that the Attorney General cannot bypass Senate confirmation by designating a new first assistant to a vacant U.S. Attorney office after the vacancy has already occurred. The court ruled that the Federal Vacancies Reform Act applies only to the individual holding that position at the precise moment of the vacancy and serves as the exclusive means for authorizing an acting official. Moving to the Eighth Circuit, the court affirmed Anthony Rondeau's conviction for aggravated sexual abuse of a minor under 18 U.S.C. Section 1153, finding sufficient evidence despite intoxication defenses. In United States v. Nicholas Peterson, the court upheld a search warrant execution where state judges in Nebraska issued warrants for records held by corporations in California, ruling that federal rules do not restrict state authority granted by state law. Over in the Fourth Circuit, Danny Roney's conditional discharge from a federal mental health facility was revoked after he violated a no-weapons condition deemed integral to his treatment regimen. The court also affirmed James Aaron Hayburn for felon in possession and attempted murder cross-references, finding reasonable suspicion for the stop and sufficient evidence for the shooting. In United States v. James Evans Hughes, the court dismissed issues covered by a valid plea agreement waiver while affirming remaining appeals under plain error review. The Third Circuit, Jose Tavares' wire fraud conviction stood because his opening statement contradicted his proffer statements, waiving protection against their admission. The 11th Circuit affirmed Barrett Purvis for wire fraud and money laundering, finding deliberate ignorance supported by evasive conduct regarding loan proceeds. William Charles Franklin faced affirmance on obstruction and assault charges involving a tractor used as a dangerous weapon, while Duber Dario Torres Tapias' conviction was upheld after counsel withdrew under Anders standards. Finally, the 10th Circuit affirmed Edwin Williams to contribute to his own medical treatment costs during supervised release, citing broad statutory discretion. The court also affirmed sex trafficking convictions for Derek Clements while dismissing his challenge to a firearm charge he was never sentenced on. In the Ninth Circuit, Cornelius Smith's firearm offenses were affirmed with evidence of his cousin's criminal history admitted to prove knowledge, and Rolando Hernandez Zamora's cyberstalking conviction stood based on prior assault convictions proving intent. Israel Castro's appeal was dismissed based on a valid appellate waiver. Back to you, David.
Thanks, James. Now for civil rights with Aisha.
Thanks, David. 7 cases today across the 10th, 11th, 8th, and 9th Circuits. The disposition mix includes 4 affirmances, 1 reversal, 1 split outcome, and 1 partial affirmation with a reversal on a specific issue. Starting with the 10th Circuit, the court affirmed Marquise Miller's dismissal against Magistrate Judge Suzanne Mitchell based on absolute judicial immunity for a discovery order she issued. Moving to the 11th Circuit, the court affirmed Title VII claims in Robinson v. Habersham County, where the plaintiff failed to prove pretext regarding her termination and denied a similar due process claim by police chiefs Finley and Reeves against Alabama Ethics Commission officials Butler, Rowlston, and Albritton. However, the 11th Circuit also issued a split decision in Blake Warner v. Hillsborough County Clerk of Courts. While upholding Florida Statute Section 11621 on its face, it reversed the summary judgment because the clerk failed to provide adequate notice by publishing in a newspaper serving less than 0.2% of the county and mailing letters to returned addresses. In the 8th Circuit, the court reversed for nurse Jessica Brady in McKee v. Brady, granting qualified immunity because pretrial detainee claims of deliberate indifference were not clearly established. The Eighth Circuit also affirmed Kenneth Hunt's Fourth Amendment unlawful arrest victory against Officer Dale Acosta and city officials in Marianna, Arkansas, rejecting arguments about excluded evidence and attorney fee reductions. I'm Aisha Johnson, covering civil rights and constitutional law. The Third Circuit issued a powerful opinion today on equal protection in public school funding. The court held that Pennsylvania's school funding formula violates the Equal Protection Clause by systematically underfunding districts with high concentrations of minority students. This builds on the state court ruling from 2 years ago, but extends the analysis to federal constitutional grounds.
Thanks, Aisha. Let's turn to Michael covering constitutional law.
Thanks, David. Today we have two substantive opinions in the realm of habeas corpus and constitutional challenges. The disposition mix is one denial and one affirmation. First, over in the 10th Circuit, Brenda Andrews' petition for panel rehearing and her request for en banc rehearing were denied, affirming the lower court's refusal to grant federal habeas relief under Section 2254 of Title 28. The court ruled that Andrew failed to prove that the admission of irrelevant sex-based evidence at her trial rendered the proceedings fundamentally unfair in violation of the Due Process Clause. Applying the standard from Payne v. Tennessee, the panel held that relief is only warranted when evidence is so unduly prejudicial as to make a trial fundamentally unfair, and found Andrews' challenge lacking because she did not show the evidence concerned central jury issues while the evidence of guilt remained overwhelming. Next, over in the 7th Circuit, Derek Fields' motion for relief under Section 2255 of Title 28 was affirmed, upholding the denial of his claim of ineffective assistance of counsel in violation of the Sixth Amendment. The court held that even assuming a late-breaking plea offer existed and trial counsel provided deficient advice regarding it, Fields failed to demonstrate the requisite prejudice required to succeed. Under the Strickland v. Washington standard, Fields could not prove by a reasonable probability that he would have accepted the plea offer had his counsel been adequate or that the court would have imposed a lower sentence. Back to you, David.
Thanks, Michael. Let's turn to Maria covering business and civil law.
Thanks, David. 7 cases in this block, 4 were affirmed, 2 reversed or remanded, and 1 issued an other disposition. Over in the 9th Circuit, the court reversed a class certification order in a deceptive advertising case involving the Happy Group, finding plaintiffs failed to prove common consumer deception regarding pasture-raised egg labeling. The court also affirmed the denial of a habeas petition from Karen Bodden, ruling her claim was procedurally defaulted and could not be excused under Section 2254 of Title 28, because she did not meet the requirements for introducing new evidence. Moving to the 7th Circuit, the court affirmed the dismissal of a False Claims Act Qui Tam case brought by A. Samuel Enlow against Heritage Operations Group and Green Tree Pharmacy, holding that his complaint failed to plead sufficient facts under Rule 9.b regarding materiality and knowledge. In the 8th Circuit, the court affirmed a judgment for Walmart in a negligent slip-and-fall case, upholding the trial bifurcation and exclusion of expert testimony while rejecting arguments about magistrate-judge jurisdiction. Over in the 11th Circuit, 2 significant rulings emerged. The court reversed and remanded an ERISA fiduciary duty case involving Royal Caribbean, holding that plaintiffs do not need an apples-to-apples comparator fund to prove loss causation when challenging investment selection. Additionally, the court affirmed summary judgment for Circuitronics in a contract dispute with Jiangmen Benlita, ruling that Benlita could not raise alter ego theories at trial without first pleading them in the complaint.
Finally, over in the First Circuit, the court affirmed the tax court's dismissal of Kaihik Holdings' petition regarding transferee liability, clarifying that while the 90-day filing period is non-jurisdictional, it remains mandatory and not subject to equitable tolling. Back to you, David.
Thanks, Maria. Let's turn to Raj covering immigration and government.
Thanks, David. 7 cases from the 1st, 10th, 11th, 4th, 8th, and 9th Circuits. All 7 were denied or affirmed. There were no reversals, vacatures, or remands in this block. Moving to the First Circuit, the court affirmed an order requiring the return of 2 young children to Canada under the Hague Convention on the Civil Aspects of International Child Abduction, holding that Canada was the children's habitual residence at the time of their wrongful retention, and that none of the respondents' affirmative defenses applied. Over in the 10th Circuit, the court denied a petition for panel rehearing and a request for rehearing en banc from Liberty Global regarding tax deductions, leaving the original panel decision denying the deduction in full force after an en banc poll failed to carry with 3 judges voting against granting it. The 11th Circuit affirmed the denial of motions to set aside a default judgment in a commodities case brought by the Commodity Futures Trading Commission against Empires Consulting and Joshua David Nicholas, limiting its review to late-filed motions and finding the appellant's arguments insufficiently briefed. In the 4th Circuit, the court denied a petition for review challenging an award of black lung benefits under Section 901-944, ruling that substantial evidence supported the administrative law judge's findings and that the Benefits Review Board's legal conclusions were rational. The 8th Circuit denied petitions from Salvadoran citizens and their children seeking asylum, withholding of removal and protection under the Convention Against Torture, holding that the proposed particular social groups were impermissibly defined by the persecutory conduct itself, and that substantial evidence supported the denial of torture claims. Finally, over in the Ninth Circuit, the court affirmed summary judgment for the Bureau of Reclamation in an environmental case involving the WIO1 Act, ruling the agency had no discretion to conduct contract-specific review or ESA consultation when converting water contracts. The court also denied a petition from Amritpal Singh challenging his asylum denial, finding that substantial evidence supported the immigration judge's adverse credibility determination based on inconsistencies in his testimony. Back to you, David.
That wraps up today's broadcast of Do It for the Case Law for Monday, August 17th, 2026. Thank you to our reporters James Taylor, Aisha Johnson, Michael Reeves, Maria Santos, and Raj Patel. Today's docket saw 53 total opinions with 33 affirmances, 6 dismissals, and 2 other dispositions. Of particular note were the 2 reversals and remands that reshaped the legal landscape in their respective circuits. Several appeals were dismissed on procedural grounds or lack of jurisdiction. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Subscribe and follow us for tomorrow's update.